Pause it. Okay, so I'm just going to play like probably the first couple of pages of this, maybe 5 minutes or so. And then if you guys want to go find it somewhere else and listen to all this, you can. And then I'm just going to make the next video part of the clothing. So I'm going to make this the final video here of arguments, but I'm not going to listen to the whole thing. And if you want to go hear it, I'm sure you can find it somewhere else.
We'll begin the final phase of our case, which is my instructions, and I'm going to instruct you on the principles of law which you are to follow in considering the evidence and in reaching your verdicts. It is your duty to follow all of these instructions.
Follow them all. All 36 pages.
Regardless of any opinion that you may have about what the law is or what the law ought to be, you must base your verdict on the law as I give it to you in these instructions.
Okay, so here's something I want to point out because a lot of people talk about jury nullification. Jury nullification is where a jury decides that the government is so out of control and that this law is so old or out of date or shouldn't be that no matter what the government says, we're going to jury nullify and vote not guilty. That's jury nullification. You used to be able to bring that up and talk about it. The courts have since ruled that you can't mention it because they don't want jurors to know they can do that. The jurors have the ultimate decision and they can do what they want. They can ignore everything. They can ignore some of it. They can ignore none of it. So this thing about you cannot put your personal opinion, you cannot, that's all bullshit. The juries can do what the hell they want, and they do.
Apply that law to the facts in the case which have been properly proved by the evidence. Consider only the evidence received during the trial, and the law is given to you in these instructions. And from these things alone, guided by your soundest reason and best judgment, reach your verdict. If any of you has any impression of my opinion as to the innocence or guilt of the defendant, you must disregard that impression entirely.
So I'm assuming the defense wanted that put in.
And decide this case
prosecution.
Solely as you view the evidence. You are the sole judges of the facts, and I am the judge of the law only.
So you're the sole judges of the facts, but only the facts that we allow you to hear, only the facts that we manipulate and we give you part of, only the facts that we withheld and we decided that you shouldn't hear. But other than that, you get the facts, make a decision. I wish people would get educated on jury duty and what is withheld from you, which is why it's so important to always vote not guilty unless the DA just does a stellar job and there's no hiding and you can tell that there's not some secret crap and, you know, a bunch of objections so the defense can't put on a defense.
Keep in mind that the information is nothing more than a written formal accusation against the defendant, accusing him of the commission of crimes. You are not to consider it as evidence against the defendant in any way, and it does not raise any inference of guilt. The information contains 6 counts of charged unlawful behavior against the defendant, and to each of these he has entered a plea of not guilty, which is a demand that the state prove every element of each crime beyond a reasonable doubt. Self-defense is an issue in this case. As to each of counts 1 through 5, and I might interject here, count 6 is no longer part of your consideration. That was the firearm charge. So that will not be something that you will need to address. You'll need to address only the first 5 counts.
So, from a jury's perspective, the DA charged 7 things, and he's already dismissed 2 before we get the case. So, the jury could reasonably conclude that the DA couldn't prove those. They could also reasonably conclude that the DA put charges on there that they didn't believe were true or couldn't prove it. So why should we believe the other 5 are true unless they proved it clear, concise, without a reasonable doubt? I guarantee you in these closing arguments, you're going to hear the prosecution, they always do it. They want to talk about reasonable, and it's not beyond any doubt. It's reasonable doubt. What's in this? They always downplay reasonableness because they want to lower the standard. The purpose of that statement, beyond a reasonable doubt, meaning they better prove it damn good with no doubt in your mind that it happened. No, Rick, it's not no doubt. It's just reasonable doubt. They always water it down and confuse. It drives me nuts listening to them explain reasonable doubt.
Count Well, self-defense is an issue in this case. As to each of counts 1 through 5, the state must prove by evidence which satisfies you beyond a reasonable doubt that the defendant did not act lawfully in self-defense. The law...
Case is over right there. I mean, if I'm on the jury, as soon as he read that, I went, they didn't prove none of this was self-defense. He ain't guilty of shit.
Self-defense allows the defendant to threaten or intentionally use force against another only if he believed that there was an actual or imminent unlawful interference with his own person, and he believed that the amount of force which he used or threatened to use was necessary to prevent or terminate the interference.
I think Kyle terminated the interference fairly well.
And his beliefs were reasonable. The defendant may intentionally use force which is intended or likely to cause death or great bodily harm only if he reasonably believed that the force used was necessary to prevent imminent death or great bodily harm.
Okay, so did you hear that? Because that's really the key of self-defense and deadly force. If you're going to use deadly force to defend yourself, you have to be in fear of seriously bodily injury, or I think he used the word harm, and or death. You have to believe that for you or for someone else. I'm always arguing with people that want to come here and talk about deadly force. And Rick, what about opportunity and intent and motive? And none of that shit matters. Deadly force boils down to, were you in fear of your life or the life of others? Period. And if you acted to protect your life or the life of others, then deadly force is authorized if you're protecting your life or others from actions that could cause serious bodily injury and or death. So if I'm hitting somebody with a feather, you can't use deadly force. If I'm hitting them in the head with a bat, you can use deadly force.
To his own person. A belief may be reasonable, even though it is mistaken. In determining whether the defendant's beliefs were reasonable, the standard is what a person of ordinary intelligence and prudence would have believed in the defendant's position under the circumstances that existed at the time of the alleged offenses.
So obviously the prosecution is not of ordinary intelligence because they don't believe any of that.
The reasonableness of the defendant's beliefs must be determined from the standpoint of the defendant at the time of the defendant's acts and not from the standpoint of the jury now. There is no duty to retreat. However, in determining whether the defendant reasonably believed the amount of force used was necessary to prevent or terminate the interference.
That was a question on whether Wisconsin had a duty to retreat. It's pretty clear because the judge just said there is no duty to retreat. Therefore, they do not have that statute. I'm just going to take a swinging wild ass guess on that. The judge wouldn't have said that if there was a law for a duty to retreat.
You may consider whether the defendant had the opportunity to retreat with safety, whether such retreat was feasible, and whether the defendant knew of the opportunity to retreat. You should also consider whether the defendant provoked the attack. A person who engages in unlawful conduct of a type likely to provoke others to attack, and who does provoke an attack, is not allowed to use or threaten force in self-defense against that attack. However, if the attack which follows causes the person reasonably to believe that he is in imminent danger of death or great bodily harm, he may lawfully act in self-defense, but the person may not use or threaten force intended or likely to cause death unless he reasonably believes that he has exhausted every other reasonable means to escape from or otherwise avoid death or great bodily harm.
Notice reasonable is used a whole bunch. And how many of you people know unreasonable people? How many people know somebody that thinks they're reasonable when they're a damn fool? So this term reasonable is so subjective to everyone, what reasonable is.
Counts 4 and 5 require intent to kill as part of the elements. Intent to kill means that the defendant had the mental purpose to take the life of another human being, or was aware that his conduct was practically certain to cause the death of another human being. While the law requires that the defendant have acted with the intent to kill, it does not require that the intent to kill have existed for any particular length of time before the act was committed. The act need not have been brooded over, considered, or reflected upon for a week, a day, an hour, or even for a minute. There need not have been any appreciable time between the formation of the intent and the act. The intent to kill may be formed at any time before the act, including the instant before the act, and must continue to have existed at the time of the act.
Wow. Cleared that shit up. Everybody got a good understanding of that?
You cannot look into a person's mind to determine intent. Intent to kill must be found, if found at all, from the defendant's acts, words, and statements, if any, and from all the facts and circumstances in this case which bear upon intent.
Now, when you hear these words and you look back at the district attorney questioning Kyle, isn't it true you intended to kill? Isn't it true you wanted to kill? Isn't it true you tried to kill? Isn't it reasonable that you knew if you shot him with that gun that it would kill him? Isn't it true that you used full metal jacketed in order to kill? That's what they were trying. See, they know you kind of got to work a trial from the rear. You know what the charges are. You work it backwards. I got to prove this. How can I prove this? I'll ask this. How can I prove this? I got a picture in this. I'll ask this. So all those questions were setting up to prove these jury instructions to the jury.
Intent should not be confused with motive. Proof of motive is necessary. While proof of motive is necessary to a conviction, proof of motive is not. Motive refers to a person's reason.
I think he said that wrong. Proof of intention to prove guilty, not proof of motive. Did he say that wrong?
It should not be confused with motive. Proof of motive is necessary. While proof of motive is necessary to a conviction.
While proof of motive is necessary, it's not.
Proof of motive is not.
He said it wrong. He said the jury instruction wrong. Am I the only one that's hearing this? He freaking said the jury instruction. He should have said, although intention is required to get a guilty verdict, proof of motive is not. He used motive for intention. Let me listen again, because somebody will be here. Rick, you need to listen. You didn't hear it right. You don't know what you're talking. Whatever.
From the defendant's acts, words, and statements, if any, and from all the facts and circumstances in this case which bear upon intent.
So, well, I'm going to slow this down because everybody, I'm always getting shit when I get shit wrong. So when I'm right, I gotta make a point.
Intent should not be confused with motive.
Intent should not be confused with motive. They're different.
Proof of motive is necessary. While proof of motive is necessary to a conviction, proof of motive is not.
He said it wrong. I can't freaking believe it. Appeal! Appeal! All right, here we go. I don't know how much that's going to hurt. Is that the prosecution, if they come back with not guilty, the prosecution can file. The only reason they came back with not guilty is because the judge told them they had to prove motive, when in fact they didn't have to prove motive. They had to prove intent. And since the judge told them they had to prove motive, we're going to overturn their guilty or not guilty verdict. Get ready.
Motive refers to a person's reason for doing something. While motive may be shown as a circumstance to aid in establishing the guilt of the defendant, the state is not required to prove motive on the part of the defendant in order to convict. Evidence of motive does not by itself establish guilt. You should give it the weight you believe it deserves under all of the circumstances.
First-degree murder, I think, requires lying in wait, pre-planning. Motive's important in that. And this, what they're charging him with, I don't think it matters. I could be interpreting it wrong. Maybe it does matter, and I'm just making something out of nothing.
The first count of the information charges that on or about Tuesday, the 25th of August of last year at the city of Kenosha in this county, the defendant recklessly caused the death of another human being, Joseph D. Rosenbaum, under circumstances which show utter disregard for human life. First-degree reckless homicide, as defined in the criminal code, is committed by one who recklessly causes the death of another human being under circumstances which show utter disregard for human life. Before you may find the defendant guilty of reckless homicide of the first degree, the state must prove by evidence which satisfies you beyond a reasonable doubt that the following three elements were present. First, that the defendant caused the death of another.
Okay, we got that element, right? He did cause the death. At medical examiner, that element's good.
Cause means that the defendant's act was a substantial factor in that the defendant caused the death of another.
One, check.
Cause means that the defendant's act was a substantial factor in producing the death. Second, that the defendant caused the death by criminally reckless conduct.
Was it criminally reckless conduct? I do not think they proved that at all. It was totally self-defense.
Criminally reckless conduct means the conduct created a risk of death or great bodily harm to another person, and that the risk of death or great bodily harm was unreasonable and substantial, and that the defendant was aware that his conduct created the unreasonable and substantial risk of death or great bodily harm. The circumstances circumstances of the defendant's conduct showed utter disregard for human life. In determining whether the circumstances of the conduct showed utter disregard for human life, you should consider these factors: what the defendant was doing, why he was engaged in that conduct, how dangerous the conduct was, how obvious was the danger, whether the conduct showed any regard for human life, and all other facts and circumstances relating to the conduct.
I was going to stop this because I'm over an hour, but I figure if you want to leave and not listen to it, you can skip it. I'll go ahead and let him finish because it sounds like he's getting through it pretty quick.
If, as to the first count, you are satisfied beyond a reasonable doubt that both elements of this crime have been proved.
Both. Should be 3, you said.
And that the defendant was not acting lawfully in self-defense, as I have instructed you on the law of self-defense. Then you should find the defendant guilty of reckless homicide of the first degree as charged in the information. If you are not so satisfied, then you must find the defendant not guilty.
I cannot believe they'll come back with a guilty. Remember, all 12 people have to agree that the state proved their case and he's guilty. On this count, absolutely, it's going to be hung or not guilty. I'd probably go with hung because there's always one idiot that's just, you know, bootlicker that's going to want to go with the DA because they don't believe defense attorneys no matter what they do.
On this count. Counts 2 and 3 of the information accuse the defendant of the crimes of recklessly endangering safety. Although the elements of each of these charges are identical, the rules of self-defense which apply to them are not.
So we're changing the rules of self-defense for each crime. Perfect. That's not confusing.
The second count of the information charges that at the same time and place, the defendant recklessly endangered the safety of Richard McGinnis under circumstances which show utter disregard for human life. The third count of the information charges that at the same time and place, the defendant recklessly endangered the safety of an unknown male under circumstances which show utter disregard for human life. First-degree reckless endangerment, as defined in the criminal code, is committed by one who recklessly endangers the safety of another human being under circumstances which show utter disregard for human life. Before you may find the defendant guilty of reckless endangerment of the first degree, the state must prove by evidence which satisfies you beyond a reasonable doubt that the following 3 elements were present. First, that the defendant endangered the safety of another human being, and the risk of death or great bodily harm was unreasonable and substantial, and the defendant was aware that his conduct created the unreasonable and substantial risk of death or great bodily harm. Great bodily harm means injury which creates a substantial risk of death or which causes serious permanent disfigurement or which causes a permanent or protracted loss or impairment of the function of any bodily member or organ or other serious bodily injury. The third element is that the circumstances of the defendant's conduct showed utter disregard for human life.
Who thinks the jury's kind of like, man, I'm getting all this. I'm gonna figure out this case from these great instructions.
Again, in determining whether the circumstances of the conduct showed utter disregard for human life, you should consider these factors: what the defendant was doing, why the defendant was engaged in that conduct, how dangerous was the conduct, how obvious was the danger, whether the conduct showed any regard for human life, and all other facts and circumstances related to the conduct.
They got a hand sanitizer on every row. Wow. Wonder who's paying for that. Oh, taxpayer money. Never mind, it's free. Something's changing.
When I was instructing a moment ago on reckless homicide, I indicated there were 2 elements. There are actually 3. I did read all of the ingredients, but I'm just going to reread a portion of that instruction so it's clear.
I wonder if he got an email. Something must have provoked him to do this.
That there are 3 elements to that crime. And I also used the word both of the elements, and it's actually 3. So I apologize for that mistake. And let's just, we'll stop with the reckless endangerment for a moment and return to the reckless homicide. And the elements of reckless homicide are that the defendant caused the death of another, that he did so by criminally reckless conduct, and the third element, which I read as part of the second, is that the circumstances of the defendant's conduct showed utter disregard for human life. And what tipped me off is, other than causing death, the reckless endangerment, which I've been reading now, has those same 3 elements. So utter disregard for human life is one of the elements of both crimes.
Okay, so he cleared that up, but he didn't clear up the motive and intent.
And in order to convict on the first count, you must find the presence of all 3 of the elements of first-degree reckless homicide, and also find beyond a reasonable doubt that the defendant was not privileged under the law of self-defense. Is that clear? Thanks. Thank you very much.
Everybody shook their head. It's not clear for me. I've been in law enforcement 30 years. It's not even clear. I've been in a courtroom I don't know how many hours. It ain't clear. Clear as mud.
Getting back to the reckless endangerment charge with respect to Mr. McGinnis, there is evidence in this case that the defendant was acting in self-defense as to Joseph Rosenbaum.
Did he say there is evidence?
The defendant was acting in self-defense as to Joseph Rosenbaum. Very much. Getting back to the reckless endangerment charge with respect to Mr. McGinnis, there is evidence in this case that the defendant was acting in self-defense.
Oh, good. Glad he said that. Hopefully they heard that.
As to Joseph Rosenbaum. The fact that the law may have allowed the defendant to use force in self-defense as to Joseph Rosenbaum does not necessarily mean that recklessly endangering the safety of Richard McGinnis was lawful. You must consider the law of self-defense in deciding whether the defendant's conduct as to Richard McGinnis was criminally reckless conduct, which showed utter disregard for human life. But the defendant does not have a privilege of self-defense with respect to Mr. McGinnis.
So, if this is true, what he just said, every citizen that has ever had a gun pointed at them by law enforcement should request criminal charges or civil relief for their crime against them. Because he just said he can't do that. He just said you can't point a gun just because you're defending your life against one person does not give you the right to point it at someone else and endanger them. So everyone that's ever had a gun pointed at them by law enforcement sounds like there was a criminal offense. Yeah, okay.
So the defendant would enjoy a privilege of self-defense with respect to Mr. Rosenbaum if you find the factual ingredients of that. But that doesn't mean that the fact that if he endangered the safety of Mr. McGinnis was privileged under the law of self-defense, because Mr. McGinnis was not attacking him.
He didn't know that. What was in the mind of him? He saw a mob running. If I see a mob running at him, I can only point my gun at the one I think is threatening me. Really? Does that make any damn sense?
However, you must consider the law of self-defense in deciding whether the defendant's conduct as to Richard McGinnis was criminally reckless conduct which showed utter disregard for human life. But he does not have a privilege of self-defense as to Richard McGinnis. The law of self-defense allows the defendant to threaten or intentionally use force against another only if the defendant believed that there was an actual or imminent interference with the defendant's person, that he believed that the amount of force he used or threatened to use was necessary to prevent or terminate the interference, and that his beliefs were reasonable. The defendant may intentionally use force which is intended to or likely to cause death or great bodily harm only if the defendant reasonably believed that the force used was necessary to prevent imminent death or great bodily injury to himself. A belief may be reasonable even though mistaken. In determining whether the defendant's beliefs were reasonable, the standard is what a person of ordinary intelligence and prudence would have believed in the defendant's position under the circumstances existing at the time of the alleged offense. The reasonableness of the defendant's beliefs must be determined from the standpoint of the defendant at the time of his acts and not from the viewpoint of the jury now. You should consider the evidence relating to self-defense along with all the other evidence in the case in deciding whether the defendant's conduct created an unreasonable risk of death or great bodily harm to Richard McGinnis. If the defendant was acting lawfully in self-defense with respect to Joseph Rosenbaum, his conduct did not create an unreasonable risk to another. The burden is on the state to prove the burden is on the state to prove beyond a reasonable doubt that the defendant did not act lawfully in self-defense, and you must be satisfied beyond a reasonable doubt from all of the evidence in this case that the risk was unreasonable.
I don't know how they could get there. There's no way that the DA proved that, in my mind.
You should consider the evidence relating to self-defense in deciding whether the circumstances of the defendant's conduct showed utter disregard for human life. The burden is on the state to prove beyond a reasonable doubt that the defendant did not act lawfully in self-defense. And you must be satisfied beyond a reasonable doubt from all of the evidence in this case that the circumstances of the defendant's conduct showed utter disregard for human life. If, as to each of these counts, you are satisfied beyond a reasonable doubt that the elements have been proved and that the defendant was not acting lawfully in self-defense, you should find the defendant guilty of reckless homicide of the first degree. If you are not so satisfied, then you must find the defendant not guilty. The fourth count of the information charges that at the same time and place, the defendant caused the death of another human being, Anthony M. Huber, with intent to kill that person. This is a charge of intentional homicide of the first degree, and you must consider first whether the defendant is guilty of that offense. If you are not satisfied the defendant is guilty of first-degree intentional homicide, you may consider whether or not the defendant is guilty of second-degree intentional homicide or first-degree reckless homicide, which are less serious degrees of criminal homicide. The crimes referred to as first- and second-degree intentional homicide and first-degree reckless homicide are different degrees of homicide. Homicide is the taking of the life of another human being. The degree of homicide defined by law depends on the facts and circumstances of each particular case. While the law separates homicides into different types and degrees, there are certain elements which are common to each crime. Both intentional and reckless homicide require that the defendant have caused the death of another. First and second degree intentional homicide require the state to prove the additional fact that the defendant have acted with the intent to kill. First degree reckless homicide requires that the defendant acted recklessly and that the circumstances of his conduct showed utter disregard for human life. It will also be important for you to consider the privilege of self-defense in deciding which crime, if any, the defendant has committed. The Criminal Code of Wisconsin provides that a person is privileged to intentionally use force against another for the purpose of preventing or terminating what he reasonably believes to be an unlawful.
See, I don't think the defense mentioned self-defense enough in their questions, in their statements, in their objections. Self-defense should be a word that the jury has heard 50 times. And I don't know if they've heard it more than 10 times, even after the judge today.
Lawful interference with his own person by the other person. However, he may intentionally use only such force as he reasonably believes is necessary to prevent or terminate the interference. He may not intentionally use force which is intended or likely to cause death unless he reasonably believes that such force is necessary to prevent imminent death or great bodily harm to himself. As applied to this case, the effect of the law of self-defense is the defendant is not guilty of any homicide offense if the defendant reasonably believed that he was preventing or terminating an unlawful interference with his own person, or reasonably believed the force used by him, and reasonably believed that the force used by him was necessary to prevent imminent death or great bodily harm to himself. The defendant is guilty of second-degree intentional homicide if he caused the death of another human being with intent to kill and actually believed the force used was necessary to prevent imminent death or great bodily harm to himself, but the belief or the amount of force used was unreasonable. The defendant is guilty of first-degree intentional homicide if he intended to cause the death of another with the intent to kill and did not actually believe that the force used was necessary to prevent imminent death or great bodily harm to himself. The defendant is guilty of first-degree reckless homicide if the defendant caused the death of another by criminally reckless conduct and the circumstances of the conduct showed utter disregard for human life. You will be asked to consider the privilege of self-defense in deciding whether the elements of first-degree reckless homicide are present. Because the law provides that it is the state's burden to prove all facts necessary to constitute a crime beyond a reasonable doubt, you will not be asked to make a separate finding on whether the defendant acted in self-defense. Instead, you will be asked to determine whether the state has established the necessary facts to justify a finding of guilty for first or second degree intentional homicide or for first degree reckless homicide. If the state does not satisfy you that those facts are established by the evidence, you will be instructed to find the defendant not guilty. The facts necessary to constitute each crime will now be defined for you in greater detail. First degree intentional homicide is defined in the criminal code as committed by one who causes the death of another human being with the intent to kill that person or
We already
another.
heard that, right?
The force used was necessary to be of first degree intentional homicide. Elements were present. First, that the defendant caused the death of another, with the intent to kill the other. Third, that the defendant did not actually believe that the force used was necessary to prevent imminent death or great bodily harm to himself. The third element of the first degree intentional homicide requires that the defendant did not actually believe the force used was necessary to prevent imminent death or great bodily harm to himself. This requires the state to prove either that the defendant did not actually believe he was in imminent danger of death or great bodily harm, or that the defendant did not actually believe that the force used was necessary to prevent imminent danger of death or great bodily harm to himself. When first degree intentional homicide is considered, the reasonableness of the defendant's conduct, when first degree intentional homicide is considered, the reasonableness of the defendant's belief is not an issue. You are to be concerned only with what the defendant actually believed. Whether those beliefs are reasonable is important only if you later consider whether the defendant is guilty of second degree intentional homicide. If as to the fourth count, you are satisfied beyond a reasonable doubt that the defendant caused the death of another with the intent to kill this is Mr. Huber, with the intent to kill, and that the defendant did not actually believe that the force used was necessary to prevent imminent death or great bodily harm to himself, you should find the defendant guilty of first degree intentional homicide. If you are not so satisfied, then you must not find the defendant guilty of first degree intentional homicide and must consider whether the defendant is guilty of second degree intentional homicide.
That's where we get into the lesser included offense they added.
As defined in the criminal code, which is a lesser included offense of the first degree intentional homicide. There are hierarchies of cases in the law. Typically, first degree is the highest offense. Then lesser included are crimes that are of the same nature with many common elements, but some differences. So there's a sequence of verdicts that are going to be submitted to you with respect to this count, and that's what we're going through at this time. So we'll take on now but let me advise you, you should make every reasonable effort to agree unanimously on the charge of intentional homicide of the first degree before considering the offense of second degree intentional homicide. However, if after a full and complete consideration of the evidence, you conclude that further deliberation would not result in unanimous agreement on the charge of first degree intentional homicide, you should consider whether the defendant is guilty of second degree intentional homicide.
So we talked about whether if they deliberate a long time, is it good for the defense or prosecution versus a short time? And I said normally if it comes back, in this case, if it comes back quick, it's good for the defense because the prosecution didn't have, they didn't prove their case. However, there are slam dunk cases to where the evidence is overwhelming and the victims are all good people and the jury has no problem voting guilty and they will come back really quick. So I said before, normally when it comes back, it's good for the defense. In a case to where the DA does a shitty job, a fast return is good for the defense. In a slam dunk case to where it's a no-brainer and you got really shitty person you're charging and really great people who were victims, a fast return is good for the DA. Okay? Now, when they're talking about these lesser included, that's sometimes why you get a longer deliberation. And it's not good for the prosecution because it kind of indicates they must have not been able to reach a verdict on the first charge, and that's why they're deliberating on the lesser included. So if you didn't prove it on the first one, your case ain't that good. Now you're hoping and praying that the second one sticks.
Before you may find the defendant guilty of intentional homicide of the second degree, the state must prove, by evidence which satisfies you beyond a reasonable doubt, that the following three elements of this crime were present. First, that the defendant caused the death of another. Second, that he acted with intent to kill another human being. And third, that he did not reasonably believe that he was preventing or terminating an unlawful interference with his own person, or did not reasonably believe that the force used was necessary to prevent imminent death or great bodily harm to himself. You have already been instructed on the definitions of causing death and with intent to kill. These same definitions apply to your consideration of second-degree intentional homicide. The third element of second-degree intentional homicide requires that the defendant did not reasonably believe that he was preventing or terminating an unlawful interference with his own person, or did not reasonably believe that the force which was used was necessary to prevent imminent death or great bodily harm. This requires that the state have proved one of the following. First, that a reasonable person in the circumstances of the defendant would not have believed that he was preventing or terminating an unlawful interference with his own person, or that a reasonable person in the circumstances of the defendant would not have believed he was in danger of imminent death or great bodily harm, or that the reasonable person in the circumstances of the defendant would not have believed that the amount of force used was necessary to prevent imminent death or great bodily harm to himself. The reasonableness of the defendant's beliefs must be determined from the standpoint of the defendant at the time of his acts, and not from the standpoint of the viewpoint of the jury now. The standard is what a person of ordinary intelligence and prudence would have believed in the position of the defendant under the circumstances existing at the time of the alleged offense. If, as to the fourth count, you are satisfied beyond a reasonable doubt that the defendant caused the death of another human being with intent to kill, and did not reasonably believe that he was preventing or terminating an unlawful interference with his own person, or did not reasonably believe that the force used was necessary to prevent imminent death or great bodily harm to himself, you should find the defendant guilty of second-degree intentional homicide. If you are not so satisfied, then you must not find the defendant guilty of second-degree intentional homicide, and you should consider whether the defendant is guilty of first-degree reckless homicide as defined in the criminal code, which is also a lesser-included offense.
I would like them to say to the juries, the burden of proof is on the government, and you must presume that the defendant is innocent. And only if you think the government proved their case beyond a reasonable doubt, then you can vote guilty. But you must presume innocence. That makes it clear.
Of first-degree intentional homicide. Again, you should make every reasonable effort to agree unanimously on the charge of second-degree intentional homicide before considering the offense of first-degree reckless homicide. However, if after a full and complete consideration of the evidence, you conclude that further deliberation would not result in unanimous agreement on the charge of second-degree intentional homicide, you should consider whether the defendant is guilty of first-degree reckless homicide, which is a crime committed by one who recklessly causes the death of another human being.
We already heard that.
The conduct created a risk of death or great bodily harm. You should consider the evidence relating to self-defense in deciding whether the defendant's conduct created the unreasonable risk to another. Beyond a reasonable doubt that the defendant did not act lawfully in self-defense, and you must be satisfied beyond a reasonable doubt from all of the evidence in this case that the risk was unreasonable. The third element is that the circumstances of the defendant's conduct showed utter disregard for human life. Again, in determining whether the circumstances of the conduct showed utter disregard for human life, you should consider these factors: what the defendant was doing, why he was doing it, the circumstances of the defendant, and you must be satisfied beyond. As to the fourth count, you were satisfied beyond a reasonable doubt that the defendant caused the death of another human being by criminally reckless conduct, and that the circumstances of the conduct showed utter disregard for human life with intent to kill that person, a crime of attempted first-degree intentional homicide, which are less serious degrees of criminal homicide. The crimes referred to as attempted first and second-degree intentional homicide are different degrees of homicide. Again, that is the taking of the life of a person is privileged to intentionally use force against another under the following circumstances. Force is used for the purpose of preventing or terminating.
All right, we heard all that.
Prevent imminent death or great bodily harm to himself, but the belief for attempted first or second-degree intentional homicide. If the state does not satisfy you, the elements of each crime will now be defined for you in greater detail. Before you may find the defendant guilty of attempted first-degree intentional homicide, the state must prove, by evidence which satisfies you beyond a reasonable doubt, that the following three elements were present. First, that the defendant intended to kill another. Second, that he did acts which demonstrate unequivocally, under all of the circumstances, that he had formed the intent and would have caused the death of another, except for the intervention of another person or some other extraneous factor. Unequivocally means that no other inference or conclusion can reasonably and fairly be drawn from the defendant's acts under the circumstances.
I think that helps him even more.
Another person means anyone other than the defendant and may include the intended victim. An extraneous factor is something outside the knowledge of the defendant or outside of his control. The third element is that the defendant did not actually believe that the force used was necessary to prevent imminent death or great bodily harm to himself. The third element of attempted first-degree intentional homicide requires that the defendant did not actually believe the amount of force was necessary to prevent imminent death or great bodily harm to himself. This requires the state to prove either that the defendant did not actually believe that he was in imminent danger of death or great bodily harm, or that the defendant did not actually believe that the amount of force used was necessary to prevent imminent danger of death or great bodily harm to himself. When attempted first-degree intentional homicide is considered, the reasonableness of the defendant's belief is not an issue. You are to be concerned only with what the defendant actually believed. Whether these beliefs are reasonable is important only if you later consider whether the defendant is guilty of attempted second-degree intentional homicide. If, as to the fifth count, you are satisfied beyond a reasonable doubt that the defendant intended to kill another human being and that his acts demonstrate unequivocally. If you are not so satisfied, then you must find the defendant not guilty. If you conclude that further deliberation would not result in a unanimous agreement on the charge of attempted first-degree intentional homicide, you should consider whether the defendant is guilty of attempted second-degree intentional homicide. Before you may find the defendant guilty of second-degree intentional homicide, the state must prove by evidence which
Jesus, man. Anybody else like
would not have believed that he was preventing, would not have believed that the amount of force used was necessary. Count you are satisfied beyond a reasonable doubt that the defendant intended harm to himself. You should find the defendant guilty of attempted whether the defendant is guilty of the lesser included offense of first-degree recklessly endangering safety, as defined in the criminal code, which is a lesser included offense of attempted first and second-degree intentional homicide. First-degree recklessly endangering safety, as defined in the criminal code, lawfully in self-defense, then you should find the defendant guilty of reckless endangerment of the first degree as submitted. If you are not so satisfied, then you must find the defendant not guilty. You are not in any event to find the defendant guilty of more than one of any sequence of offenses. So you can return only one verdict per count. You should consider the charged offense first. If you find unanimously that the defendant is guilty of the highest degree of crime, you need not consider lesser included offenses. If you decide unanimously the defendant did not commit the greater crime and was acting lawfully in self-defense,
somebody sleeping or something? What's the judge doing? He's pissed off about something.
I've got myself into a mid-sentence and I don't like it.
Oh, sidebar. Didn't we already talk about the appeal court don't like sidebars because it's off the record and we don't know what they're talking about, etc.? It almost like he saw one of the jury sleeping or something and he was upset. What a weasel. Oh, man, I have such disdain from this guy. Him and Jeff Reisig might be brothers. Wow. So we don't know what's going on. He's smiling, so it must be some misconduct. He hasn't smiled since he's lost part of his ass from the judge chewing on it. See if he can find out what the hell went on here.
The concern that I have, and I've worked with the instructions all weekend, and we discussed them by email, and then I'm reading them, and little things are striking me as I read them. But the jurors are never told to actually discuss self-defense except in the context of charged offenses. And what I was about to say to the jury, and decided I better talk to you people beforehand, is if the jury gets into a discussion of a charged offense, any charged offense, but let's use this one as an example, and they decide that he's the elements are there and he wasn't acting lawfully in self-defense, they're done. They never discuss the lessers. What?
Was or was not acting lawfully in self-defense?
Well, let's say if they decide the elements are there, but he was not acting lawfully in self-defense, they're done. Then they find him guilty of the charged crime. What if they discuss count 1, or count 5, I should say, and decide that the elements are there, but they all decide it was privileged under the law of self-defense? They're not.
When he says privilege, self-defense is a privilege. Notice it's not a right. The government can take it away. Government loves privileges. They don't like rights.
Is there anywhere that they're being told? Are they being told you're done? See, under the old law, we did do that. Is that
I'm assuming the jury left. I didn't see the jury leave. Did they make the jury leave?
in here? Where is it saying that? Yeah, that's what I used to construct these from scratch. And I would tell the jury, which I was just doing now, that, you know, once you have exhausted this, you're done. As opposed to having them needlessly go through these lessers if they've already concluded that, and this is a case where this could happen. I'm not saying it should or would. I'm saying it could, that they would decide, well, yeah, the elements are there, and then they make a decision. And if all of them say, well, they all vote not guilty on the basis of
self-defense,
of valid self-defense, then they really should not be considering lesser included.
That's good.
Am I right or wrong about that?
So if they find perfect self-defense on the charged count,
Yeah.
they should be told,
ignore the lesser. Perfect.
You see what this? Yeah, I'm sorry.
I mean, I understand where the court.
How can he be, if self-defense is a prelude to getting rid of the charge that he acted lawfully, if they find it in the first one, how can they go to the lesser offenses if he uses self-defense? They've already said that he used self-defense on the first one. Why do we have to consider the other charges? If self-defense is evident, the other charges are gone too. Man, that's a great, that's why he's smiling. Because that's a great freaking catch by the judge.
Where it's coming from, I guess they could consider the other ones in 30 seconds and just go down to be not guilty. But
oh, see, they're still being weaselly. They still want. Well, they could just settle them in 30 seconds. Then that's bullshit. So he's hoping maybe in that 30 seconds, one of them will get confused and vote guilty or hang. Man, these guys are they will do anything, including planting evidence, intimidating witnesses, calling witnesses liars, disparaging witnesses. Call that one lady who was out there trying to do good, hating, called her racist because Black Lives Matter said they were going to beat her up or some shit. I mean, these guys are just so unethical and ruthless pieces of shit for human beings.
They're so complicated as it is.
no, I understand.
I feel terrible about giving this kind of stuff. It's just so. Well, anyway, you don't see what the instruction is telling them that kind of cryptically. It says it tells them if after a full discussion.
I think somebody got to Kyle about smiling because he hasn't smiled since that first couple times. And I've seen him yawning. He holds his mouth when he's probably got a headache. He's yawning. He hasn't sleeping. I mean, it
says, however, if after a full and complete consideration of the evidence you conclude that further deliberation would not result in unanimous agreement on the charge of second-degree intentional homicide, I'm going back to a different count, you should consider whether the defendant is guilty. So it is telling them. It is telling them. Yeah, I just think it's kind of unclear.
I think it's very unclear. What you're saying is the law. So they all agree that the elements are met, and there's a privilege. You don't go any further.
Pardon me?
I believe the pattern instruction makes that clear enough. If they can unanimously...
See, he's going to say the instructions are clear enough. Who thinks the instructions are clear? The judge thinks they're unclear. But they think they're clear because they like unclear. They like confusion. They like smoke and mirrors. They're the government. They got nothing to lose. They get paid either way. Someone else goes to jail. What do they care? God, man, government, you gotta love them.
Agree, which includes the privilege, they're done. They don't have to go forward.
Where does it use? It says you should make every reasonable effort to agree unanimously on the charge of second-degree intentional homicide before considering the offense of first-degree reckless homicide. However, if after a full and complete consideration of the evidence, you conclude that further deliberation would not result in unanimous agreement on the charge of second-degree homicide, you should consider whether the defendant is guilty of first-degree reckless homicide. So, I don't think it's not the way a person would speak if he wanted to make things clear. And I'm not saying anyone deliberately is trying to make things unclear, but
I think one can say that about all 30-some pages of the.
don't do that. People will find out our lawyer secret.
I think it's clear in the instructions. If the court did wish to make it clear, I would just say, just explain if you're unanimous either way on the first count. There's no need to go to the lessers.
Yeah, I think that's a good way to do it. I think I'll tell them that in any sequence, if there are lessers submitted to them, once they've discussed the highest count, if they are unanimous either way, then they're done. Does that make sense? No, Mr. Binger's having a problem with that, and let's see where he is.
Of course he is.
I don't like the way I said that either.
Mr. Binger, got a problem. Cards aren't stacked in my favor. I can't confuse people. I don't want it fair. I don't want anything clear. Unethical weasel.
In any count where there are multiple.
I want him to say, once you prove self-defense, you're done. That's what I'd want him to say.
Verdict submitted to you. If at any point in your deliberations you are unanimous as to both the elements, the presence or absence of the elements of the crime, and the presence or absence of the right of self-defense, you need go no further.
That's confusing.
The reason I was shaking my head is because, let's take Anthony Huber's counts, for example.
Yeah.
If the jury is unanimous that he is guilty of first-degree intentional homicide, they go no further.
Right.
If they are unanimous that he's not guilty of first-degree intentional homicide, then they are instructed to consider second-degree intentional homicide.
Only if they're not satisfied that it was done in self-defense. If they, for example, if in your example, if they discussed it and said, well, sure, the elements of attempt murder are there, and then they go around the table and they say, well, we all think it's not self-defense, then guilty. If they all say we don't think it's, well, actually, if they all say we don't think it's self-defense, then it's not guilty. And what the jury is being told is if you can't agree unanimously, then consider these lessers. But I don't think it's so clear as it should be.
It says if you are not so satisfied.
I know it. Well, that's at the very end.
And I think what the court was originally proposing is telling the jury that if you're unanimous on the charge count one way or the other, then you go no further.
I like that.
That's not the law.
If you're unanimous on...
So, for example...
if you're unanimous on the legal question...
If you're unanimous with the reason of self-defense, then you don't go any further. Obviously, I've already told him, if you're guilty, if you're unanimous and he's guilty, you don't include the lessers. But if it's not guilty, unanimous because of self-defense, you don't go further either. And that's what he doesn't want to tell him.
Question. Intentional? Well, you're right, because it could be an elements issue.
The jury...
Maybe the constructions committee is right. I don't know.
The jury only goes to lesser included if they are either unable to agree on the charge count or if they're unanimous not guilty on the charge count. Then they go to the lesser included. So there is no requirement that they be unanimous on the charge count to move to the lesser.
No, they shouldn't be unanimous. If they're unanimous, then they're done. That's what I'm trying to tell them, but I don't know how to say it.
That's not true, because if they're unanimous on first-degree intentional homicide, what they're concluding at that point is that the defendant, either the elements aren't met, or the defendant actually believed that deadly force was necessary. They would still then have to consider the second-degree intentional because it changes the self-defense into the objective, reasonable one. So they can be unanimous.
Unfortunately, I think he's right.
On count one, let's take Huber, for example. They can be unanimous on the first-degree intentional homicide. They can be unanimous on that, and in the defendant's favor. But they still have to then move to the second element, or to the lesser included.
He did say that the self-defense changes on the other lessers. I remember him saying something like that. Of course, it was so confusing. I have no understanding or on how to apply it, but I do remember him saying something.
You might be right.
Perfect self-defense.
Pardon me?
If it's perfect self-defense, it's perfect self-defense for everything.
But they're not told to consider perfect self-defense on first-degree intentional homicide. They're specifically told.
It's fine.
Well, yeah, you're right. He's right.
They're not told to consider that until second-degree intentional homicide. The instructions, Your Honor, are the pattern instructions. I understand your point that if we had to redraft them today from scratch, maybe we could do better. But I'm sure we could. But we need to follow them, and I don't think deviation is appropriate.
I think you're right. And they are certainly correct in what they say. I just think that they're not clear. But maybe they are. I don't know.
Yeah, who cares? It's just pesky juries. If they get it wrong, guy goes to prison. I mean, what do you want us to do, man? We got coffee and lunch to worry about.
Now let's see how much damage I've done already by my last paragraph. So can you go back to what the last thing I said to the jury?
Defendant is guilty of the highest degree of crime, you need not consider lesser included offenses. If you decide unanimously the defendant did not commit the greater crime and was acting lawfully in self-defense, and then that's when you stopped in mid-sentence.
So the first part was right. Did not commit the greater crime and was acting lawfully in self-defense. You know, if he was acting lawfully in self-defense, the ball game's over. Yeah, I think that's correct. Even your suggestion is seductive, Mr. Binger, but but see, they're not asked to consider that. That's where I'm having the problem. And they even make reference to it. I think maybe I read in one of the comments. They talk about we don't have, like some states do. They have a question right off the bat: was the defendant acting lawfully in self-defense? If they answer that yes, we're all done. We've got it interlaced in all these cumbersome instructions, and
that's good. That should be an easy way. Was he acting self-defense? Yes, we're done. That would be perfect.
No. Does anyone have any objection to what I've already told the jury?
Finish it.
And tell them what?
Just what we said. If you find perfect self-defense, you don't go on to the next count. It's over.
I understand what the term perfect self-defense means, but we haven't told the jury what that means. We're deviating from the standard instructions here, and the words perfect self-defense don't have a meaning to ordinary people, would require further definition from the court, and now we're going much further afield. I also have a problem with the wording of, do we...
You got a problem with freaking Charmin toilet paper not being soft enough for your big ass. Whatever, dude. You'd have a problem if anything hurt your case. You would have no problem if it helped your case.
If you find the defendant is justified in his self-defense, because we've instructed them on his own subjective self-defense belief, which is a defense to the first-degree intentional homicide, and then we've given him the instruction on what the law considers to be objective self-defense, is what a reasonable person would think. When the wording that was just read by the Madam Court reporter doesn't delineate between those two things, and I think, as I said, and I've repeated here several times, I think the more we deviate from these standard instructions, the more confusion it causes.
See, he doesn't care about confusion or deviation. He wrote them so they would confuse him. He wrote them to help him, and he doesn't want them changed. That's what he's really saying, but he's so good at lying he can never tell the truth. Outrageous.
Counsel has asked you to read the self-defense individually on each count. So they're already being told on each count that you are to consider the final thing is the objective self-defense, and that is if you find that, then he's not guilty. And to say across the board that you find self-defense is a defense to everything is not technically true, because there are different self-defense claims as to the different counts. So, for example, he may be justified to self-defense as to Rosenbaum, but not as to Huber. So a blanket statement that says anytime you find justified self-defense, he's not guilty, is not technically true.
Well,
So again,
it is if you're talking just about an individual count.
But I was saying blanket.
And I think what I'm going to tell them, in addition to what I've already said, is if they are discussing a count that has multiple possible verdicts.
I think the standard instruction already spells that out, Your Honor.
See, he does not want to let him say what he wants to tell him. I mean, he's a good weasel, but I mean, used car salesman can be a good liar and be a good used car salesman. Doesn't make him a good person. He is paid by the taxpayers to get justice and to do the right thing, not to manipulate justice just to get a win.
I agree. If we had to do it from scratch, we could do it better, but I don't think we should deviate any further because I think it's causing confusion. What Madam Court Reporter just read back, for example, could be construed as saying, anytime with regard to any count you find justified self-defense, he walks on all 5 counts. And that is absolutely not true.
That's not what I intend to tell them at all.
I know you don't intend to tell that, but what's already been said gives that implication. And again, I just worry that the more we deviate from these standard instructions, the more we get into these issues. I think we should stick with what you drafted, which has been sent to the parties. We've all agreed on them, and I am leery of any additional language that hasn't been cleared by the parties.
Who thinks if he found a way to change something that helped his case, if he'd want to change them? Of course he would.
And could cause further confusion.
Well, and I can say that whenever I've dealt with lesser included, I do give a little talk about how they should address them. And this is a more complicated case than most, than any, frankly, that I can remember. I don't think I've said anything incorrect so far. I don't want to step into something that I haven't already done. I am inclined, though, because I've made a statement about if everything's present, they're done because they found the defendant guilty, and I do think I probably should give the alternative, which is, and I'm not going to use terms like perfect self-defense like he did. I'm going to use the term acted lawfully in self-defense, and they're instructed on that. So I think the correct statement is, if as to any of the cases with multiple submissions, if
you find that
on any individual count, they find in their consideration of the charged offense that the defendant acted lawfully in self-defense, they're done.
Good.
Any objection?
No.
Okay.
While we're talking about the jury instructions, it was noticed as you read them on page 10, which is count 3, it should be first-degree reckless endangerment, and it's written and you read homicide, which is not a homicide count. So
on page 10?
Top of page 10 on count, still at the end of count 3, it says you should find the defendant guilty of first-degree
you're right.
homicide.
You're right. It is in there as homicide. We didn't catch that last night when we talked about him. I sent you 3 drafts. But you know what? Should I just leave that alone? They'll know that. I'll change it in the printed copy.
That's fine.
Okay, thanks.
Are you anticipating closing before lunch now? It's after 11.
How long are you going to talk in your first sequence?
I'm going to try and limit myself to 2 hours.
So he wants 2 hours for his first bite at the apple, and then another half hour at his rebuttal. And he's going to go over the time limit. I guarantee you right now.
Are you troubled by taking a break in the middle of your presentation? Well, let's just kind of plan on around noon, because the lunch has already been ordered, so, and I'm not going to comment on the lunch. So let's ask the jurors to come back in, please. So I'll take a break at, why don't you, around, whenever you're comfortable, around noon, just ask for the break. Yeah, well. Was not acting lawfully. If in your discussions you conclude that the elements are present and the defendant was not acting lawfully in self-defense, then you needn't go any further. You can return your verdict of guilt based upon that conclusion. If in your discussions as to any individual count of those with multiple possible verdicts, in your initial discussion, if you decided that the defendant acted lawfully in self-defense, you're done. And you can return a not guilty verdict without considering the lesser offenses.
Perfect.
Any question about that?
I think that made it a lot clearer because I was confused as a freaking newborn baby in a freaking topless bar. I don't know what the hell he was talking about, and I've freaking been in a courtroom I don't know how many times for this shit. They make it so confusing, no reasonable person understands it. If they read these jury instructions and then gave a test to the people that they read the jury instructions to, 99% of the people would fail the test. Guaranteed.
It hopefully will become clear. I'm going to give you written instructions because I know this is arduous going through this, but every bit of it is important. But you'll get written instructions for your reference in considering these things. Verdicts of any submitted offense contain a question based upon the allegation of the information that the defendant committed the crime while using a dangerous weapon. If you find the defendant guilty on any of the counts, you must answer the following question. Did the defendant commit the crime while using a dangerous weapon? Dangerous weapon means any firearm, whether loaded or unloaded. A firearm is a weapon which acts by the force of gunpowder. Before you may answer the question, yes, you must be satisfied.
A weapon is used by gunpowder? That should be a firearm. He said weapon. Should be firearm. Because a knife can be a weapon and it doesn't use gunpowder.
Satisfied beyond a reasonable doubt that the defendant committed the crime while using a dangerous weapon. If you are not so satisfied, then the question must be answered no. In reaching your evidence, examine the evidence. In reaching your verdict, examine the evidence with the utmost care and caution. Act with judgment, reason, and prudence. The defendant is not required to prove his innocence. The law presumes every person charged with the commission of a crime to be innocent, and this presumption requires a finding of not guilty, unless in your deliberations you find that it is overcome by evidence which satisfies you beyond a reasonable doubt that the burden of establishing every fact necessary to constitute guilt is upon the state. Before you may return a verdict of guilty, the evidence must satisfy you beyond a reasonable doubt that the defendant is guilty.
Now, some of you might be thinking, man, that's kind of a high bar, man, for the DA to... It is a high bar. It's a pain in the ass. I hated it. A lot of guilty people walked because we couldn't do it. But the reason it's there is to protect innocent people. Our whole theory is that 10 guilty people should go free versus one innocent person going to jail. We wanted a just legal system. We didn't want it rigged with weasel DAs manipulating evidence, witnesses, and confusing the jury. That's not the intent of our justice system. And it's been morphed into this support of DAs only.
If you can reconcile the evidence upon any reasonable hypothesis consistent with the innocence of the defendant, then you must do so and find him not guilty. The term reasonable doubt means a doubt based upon reason and common sense. It is a doubt for which a reason can be given, arising from a fair and rational consideration of the evidence or want of evidence. It means such a doubt as would cause a person of ordinary prudence to pause or hesitate when called upon to act in the most important affairs of life. A reasonable doubt is not a doubt which is based upon mere guesswork or speculation. A doubt which arises merely from sympathy or from fear to return a verdict of guilt is not a reasonable doubt.
He's gone through this so many times he doesn't have to read it. He's memorized it. It's kind of like when a cop says, you know, the right. You have the right to remain silent. Any right thing you say can and will be used. You say it so many times you know it. That's why he's going off memory, he's not reading.
A reasonable doubt is not a doubt, such as may be used to escape the responsibility of a decision. Examine the evidence and search for the truth, giving the defendant the benefit of evidence.
Search for the truth and give the defendant the benefit of the doubt. How can they not, with that one statement, come back not guilty on everything?
Every reasonable doubt. Evidence is defined first as the sworn testimony of witnesses, both on direct and cross-examination, regardless of the party who called the witness. Second, any exhibits which have been received, whether or not they accompany you to the jury room. Third, any facts which the lawyers have agreed or stipulated, or which I have directed you to find. Anything that you may have seen or heard outside the courtroom is not evidence. You are to decide the case solely on the evidence offered and received at this trial. You should disregard entirely any question to which I did not permit an answer. Do not guess what the witness's answer might have been, and if the question itself suggested that certain information might be true, ignore the suggestion and do not consider it as evidence.
I wonder if there's a weasel instruction. Do not consider that the DA is a weasel and that he's lied and that he looked like a freaking idiot and he's a vindictive piece of shit that just wants to put somebody in jail whether they're guilty or not. You must ignore that fact. There should be a weasel jury instruction.
Attorneys for each side have the right and duty to object to what they feel are improper questions asked of witnesses, and to the receipt of other evidence which they believe is not properly admissible. You should not draw any inference or conclusions from the fact that an objection is made. By allowing testimony or other evidence to be received over objection, I did not mean to indicate any opinion as to that evidence. You jurors are the sole judges of the believability of the witnesses and of the weight of the evidence. At the beginning of the trial, I described the charges against the defendant, counts 6 and 7, which respectively charged possession of a firearm by a minor and curfew violation, have been disposed of and are no longer part of this case. The other counts remain. Do not guess about or concern yourselves with the reasons for these dispositions. It must not affect your consideration of the charges that remain.
More government tricks. I will charge a guy with rape, murder, sexual assault, killing a dog, and then I'll dismiss him after you've heard him. Now, I'm not saying they did that, but that's what DAs do. You overcharge everything, and then when you get in a trial, once the jury hears you've already painted the guy as a piece of shit, then you just start dropping charges, and the ones that are left, they'll probably find him guilty. That's BS.
Do not consider evidence that related only to the counts which have been disposed of. During the trial, I have ordered certain testimony stricken, and you must disregard all such stricken testimony. Exhibits become evidence only when received by the court. An exhibit which was marked for identification but not received is not evidence. Whether or not, is not evidence. An exhibit received is evidence whether or not it accompanies you to the jury room. Remarks of the lawyers are not evidence, and if the remarks suggest certain facts not in evidence, disregard the suggestion. You should consider carefully the closing arguments of the attorneys, that their arguments, opinions, and conclusions are not evidence. Draw your own. That's
key. He should have really made clear that. The closing arguments you're going to hear is not evidence.
Conclusions from the evidence and decide upon your verdict upon the evidence under the instructions given you by the court. I have taken judicial notice of certain facts, and you are directed to accept them as true. The state has introduced evidence of statements which it claims were made by the defendant. It is for you to determine how much weight, if any, to give to any statement. In evaluating each statement, you must consider 3 things. Whether the statement was actually made by the defendant. Only so much of a statement as was actually made by a person may be considered in evidence. Whether the statement was accurately restated here at the trial. Whether the statement or any part of it ought to be believed. You should consider the facts and circumstances surrounding the making of each statement, along with all other evidence, in determining how much weight, if any, the statement deserves. The weight of the evidence does not depend on the number of witnesses on each side. You may find that the testimony of one witness is entitled to greater weight than that of another witness, and you may give it such weight in considering your verdicts. In weighing the evidence, you may take into account matters of your common knowledge and your observations and experiences in the affairs of life. Ordinarily, witnesses may testify only about facts. However, witnesses with specialized knowledge in particular fields may give opinions in those fields. In determining the weight that you give to these opinions, you should consider the qualifications and credibility of the expert, the facts upon which the opinions are based, and the reasons given for the opinion. Opinion evidence was received to help you reach a conclusion. However, you are not bound by any witness's opinion. It is your duty as jurors to scrutinize and weigh the testimony of the witnesses and to determine the effect of the evidence as a whole. You are the sole judges of the credibility, that is, the believability of the witnesses, and of the weight to be given to their testimony.
Just so you know, the weasel, D.A. Binger, is not a witness. Okay? So he's not supposed to give him testimony, and he's not questioned, and he's never cross-examined. Although he acts like the most informed guy out there, he's not a witness.
In determining the credibility of each witness and the weight you give to the testimony of each, you should consider these factors: whether the witness is interested or disinterested in the outcome of this trial, conduct, appearance, and demeanor on the witness stand.
Kind of like the 2 brothers that didn't want to get sued. Their testimony was shit.
The clarity or lack of clarity of the witness's recollections, the opportunity which the witness had to know and observe the matters and things about which testimony was given, the reasonableness of the witness's testimony, the witness's apparent intelligence, bias or prejudice, if any has been shown, possible motives to falsify, and all other facts and circumstances during the trial which tend either to support or to discredit the testimony, and then give to the testimony of each witness the weight you believe it is entitled to receive. The defendant has testified in this case, and you should not discredit his testimony just because he is charged with a crime. Use the same factors to determine the credibility and weight of the defendant's testimony that you use to evaluate the testimony of other witnesses. There is no magical way for you to evaluate the testimony. Instead, you should use your common sense and your experience. In your everyday lives, you determine for yourselves the reliability of statements made to you by others.
How many people do you know that think everybody's either lying or everybody's telling the truth, or they can't read a book if it was open for them and read out loud for them? I mean, to say that each of these people are good judges of character is just crazy. We have no idea what kind of judges of character you are. Hopefully, when you're questioning the jurors and picking them, you get a feeling, but there's no way of knowing.
And you should do the same thing here. Evidence has been received. The two of the witnesses in this trial have previously been convicted of crimes. This evidence was received solely because it bears upon their character for truthfulness. It must not be used for any other purpose. We're going to hear the closing. You know what? Does anybody want a break, even just a short one, or not? You want to go right into your discussion? Anybody need a break? Okay. We're going to hear the closing arguments of the attorneys now, and we follow the classical debate format in the court. That is that the proponent of a proposition is entitled to give the first and the last argument. So Mr. Binger will address you first on behalf of the state, then Mr. Richards.
Okay. I'll go into closing statements by each of them.